Two, three. Hello, everybody. Welcome. Thank you for being here today. My name is Kevin Burke. We are at the Greater San Diego Association of Realtors, and it says I have a whole bunch of people here, but I don't see who they are. Okay, all right. Well, we're going to roll anyway. We're at the Greater San Diego Association of Realtors. There's my telephone number. There is my email address. I am more than happy to help you in any way that I can. You just have to ask. It's not a problem. Happy to be here. I do have some credentials that make me qualified to speak about the subject matter today. I've been in real estate for well in excess of 40 years. I have a broker's license in several states. And I do teach continuing education for attorneys. And by the way, the class today will be similar to one of those classes. On the right-hand side of the page, you can see all the risk management things. I'm big into risk management, and I'm going to tell you something that with the preliminary title report, which is our subject matter today, very, very important that you know how to explain it. I have yet to find someone who can explain it to me, and so we're going to cover some interesting stuff. And I don't think it's that complicated a subject. I think it's just like everything else; you got to read it. So let's go ahead. We'll move forward a bit here. We're going to be talking about things that appear to be legal. I'm not a practicing attorney. I want to make that very clear. I do a lot of trial work. Mostly testifying as an expert witness. Standard of care is my specialty, agents' duties of inspection and disclosure, and market conditions in San Diego County. And so far, I'm telling a pretty convincing story. People tend to believe me. And as you saw from my wall of fame up there, I did not put in that I'm the chair of the expert witness forum, but that's I'm going to be chair of expert witness next year as well. Anyway, so that's my specialty. So conversation today not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. And again, if you have any questions or they have any questions, always feel free to reach out to me anytime I can help. I'm happy to be there. Our webinars are intended to be interactive. Please utilize the Q&A button to ask questions or offer input. I do look forward to hearing from you. And so it really helps me when you ask questions because it helps me guide the direction that we'll be talking about today. So that being said, this morning we talked about open house safety, which I think is critically important. And this afternoon, we're going to talk about how to read a preliminary title report. And that's going to be our subject matter. On Thursday, we will talk about top 10 risk avoidance techniques. And then on Thursday afternoon, we will discuss top 6 disclosures. So it's definitely a risk management week. That being said, member benefits will move forward. See, I've got people. Hi, Diana. People joining here. Member benefits, thank you for joining us for our discussion of what we refer to as Agent Toolbox, how to read a preliminary title report. This webinar is not intended to make you a legal professional, nor is it intended to be an exhaustive dissertation on all of the issues that are found in a report. I hate it when I make mistakes, nor is it intended. Okay, all right. Well, we'll get past that. I'll get over it. Or in other reports, by the way. But we're gonna hit a lot. Let's go ahead and get going. The webinar is intended to help you understand your potential obligations and the red flags associated with the preliminary title report. And so, it always amazes me when I get that phone call from the buyer that says, when do we get the title report? When do we get title insurance? And so remember that the preliminary title report is preliminary to the issuance of an actual title report. That actually comes after the transaction is closed. So you may not sue on it. It doesn't have any legal standing. It just says that at this point, this is what we have to work with. And so we're going to go over the details of that today. And I've often been told that I can make any dry subject sound really interesting. And I think this is one of those events. This is kind of my flagship class. So Remember that a preliminary title report, otherwise known as a prelim or a PR, is not a policy of title insurance. And so, as I said, you may not sue on it. It is preliminary to the issuance of a policy of title insurance. And so you will find in your experience that they will get a policy of title insurance over to you, but they will also be checking again prior to closing, or as we call it in Southern California, settling in other areas. They will review the information, make sure nothing special has happened since that time. They'll check their work, so to speak, dot the I's, cross the T's, that kind of thing. And so prior to actually issuing the policy doesn't exist until after the transaction has closed. There are special circumstances where it could exist prior to it closing, and that's usually going to be if you have a binder put on a property, or I know I was representing people that were buying 400 of these of the pre-foreclosure property, 400 foreclosure trustee sale property. So they were at the trustee sale buying homes, and they were getting binders from the insurance company to cover them just in the event that there was something going on. Because normally when you do when you purchase a property at trustee sale, the only title that you get is normally what we refer to as a trustee's deed. Some people refer to them as sheriff's deeds, but a trustee's deed is a deed that says we're going to give you our interest in the property that we have, but we don't insure against anything else. And so it's not a very high form of grant deed. Again, you only get the interest that that person who is selling the property has. There may be IRS tax liens, there may be other things that would jump in front of you, a first, a second, things like that the binder would hopefully protect you for. And so that's the rare occasion when you get a policy of title insurance prior to owning the property. So the policy of title insurance arrives approximately 30 days after settlement, what we refer to as after closing or after settlement. COE, again, in Southern California, that's what we call it. So usually shows up about 30 days later. It's got eagles on it and stuff like that, and arrows and things. And so that's the official seal and the official title insurance policy. So now, by the way, not all states require title insurance. In fact, California doesn't require it. I know I've purchased quite a few homes in other states, and at the last minute I'm going, where's that title insurance policy? And so of course the buyer gets the bill for that in other places, and so I've ended up having to pay that bill just to make sure that I actually had an enforceable policy of title insurance. So I say that there's no law that requires it, and yet most of us know that when we do a real estate transaction, the lender requires it. So that's very common. The lender requires the policy of title insurance, and why is that? That's to protect the lender, right? And so the lender wants to make sure that their interests in the property are covered, that their interests in the property are insured. So you'll usually get a title insurance policy from the seller, which will cover the seller's interest in the property, and we're going to talk about that. They'll give us whatever title they have, et cetera, et cetera. But and they'll assuming you get the right policy, they will also guarantee you against other people coming after you for your title policy. They will help defend you in that, and that's why they have title insurance. The lender's going to ask for an Alta lender's policy, and that lender's policy will be the policy that insures the lender's interest. And so that figure tends to be a lot lower than the actual policy of title insurance, but the buyer normally pays for that. And so the seller's policy, again, insures the title of the property. The Alta lender's policy insures the lender's interest in the policy. In Southern California, we have usually the title company that does the seller's policy also would necessarily do the lender's policy of title insurance. And again, no law requires it, but if you have it, this tends to be, it's supposed to be a negotiable item between the buyer and the seller. It tends not to be. Just remember that it is a RESPA violation if the seller requires the buyer to use a particular title company. There's a lot of strings attached to that. The buyer has a government insured loan, an FHA, VA, Fannie Mae, Freddie Mac, government loan, so to speak. That's but there's no RESPA violation with cash transactions, things like that. My advice has always been for my cash buyer that they still get a title policy, even though the company is not, or I'm sorry, there is no lender to require it. The buyer really needs to have that policy to ensure themselves that they actually have title of the property and, frankly, marketable title. So we're going to dig into this all here in a minute or two. Okay, so the title plant, so that's the location where the title tends to be processed. I think we're doing a transaction right now, and the title plant is in Irvine. There's another title plant in San Diego for a different title company. So they're the ones that prepare the report. Then the title officer, otherwise known as the TO, signs off on it. Now, this is not to be confused with the title rep. And so these companies hire people that are salespeople that sell the policy, that reach out to the agents, that kind of thing. That's their client. They reach out to the agents and try to get them to use their particular title policy, and that's their job. They don't know what the title officer knows. They tend to be fairly knowledgeable depending on their years in the business and their experience level, but the TO is the one. I had a TO for a very large company come in and speak to one of my law classes at the university, and about every other sentence he said, or whatever, Mr. Burke, Professor Burke, he referred to me, Professor Burke says, and I finally had to tell him we've stopped saying that. I mean, if you make an error, I'll let you know now, and then or I'll correct it later after you've left. But he was doing fine. He knows what he's talking about, and but I end up having to defend these claims. So they tend to be really good. With title insurance, if you don't have title insurance and you don't have any insurance, that's one way to go about things. But the other way to go about things is that you have in other states, where they don't have title insurance, where they are not a title theory state, they are a lien theory state instead. Now we have attorneys drafting opinions of title, and if there's an error, you sue the attorney based on their malpractice insurance. With a title insurance state, which we are essentially in California, now you sue on the insurance. In my experience, which is as we said earlier, I got my license in '79. I think the only claim I've ever had against title was a transaction I did in 1984, I believe it was, where I represented a buyer purchasing a piece of land. It was 3 1/3 acres. I'll never forget it. It was out in the middle of the Tucson desert, and there was a mobile home on it. And I sold that property, and it turned out, and I remember the sales price was $33,000, and so we did the sale, only to find out later on that there was a $28,000 second, unrecorded second on the property, and so the title company literally decided that they were going to honor that claim, and so they literally bought the property back from the buyer, and then they went after the seller because there were some issues, some legal issues of concealment, et cetera, that they needed to cover. So the only claim I've ever had on a title insurance policy, and so title insurance, I believe in it. I think it's a good thing to have. Okay. After the TO signs off on it, then it's sent to the escrow officer, who then transmits it to the parties. And the reason we like them doing that is because it's timed. It has a lot of legal catches to it. And obviously some contingency periods, and from your purchase agreement that the buyer has 5 days from receipt of the preliminary title report to review it and to approve it prior to moving forward. And so that's going to become a pretty relevant topic as I discuss a couple of really good lawsuits with you that were interesting for us as an industry. So again, it's time and date stamped. It's there's no secret as to when it went out. People sign receipt. And then they approve it after, usually after the period of time necessary to do that. So, you definitely want to make sure that you have your prelim done prior to the buyer owning the property. So, and we're going to see a court case called the field case. We're going to talk a little bit about that. I'm going to explain some things to you of what could possibly go wrong if the buyer was not aware of certain restrictions on the property, certain encumbrances on the property. Okay, so at least in Southern California, right? So that's just kind of how it is. Northern California does it a little bit differently. They have the title company and the escrow company are the same company. I worked under those conditions in Arizona for many years. We would go into the title officer's office, and at that time we would sit down at the table together. Everybody, the buyer and the seller would meet, and the title officer would exchange paperwork back between the two of them, and then the buyer would typically, the seller would typically leave, and then the buyer would stay and sign the loan papers and things like that. And so, interestingly enough, everybody checked the guns at the door, that kind of thing. Although we never really had any problems with anything like that. So that's how it is done in some places. Important rule to remember. And so the important rule is going to be never ask the client, how do you want to take title to property? Now, why? Because the manner of taking title has significant tax and legal consequences. So I always tell people when they're drafting up their offer, never say, how do you want to take title of the property? Instead, we want to say, because that assumes tax and legal advice. Instead, how do you want your name to appear on title? Because why? Because when the buyer takes title to the property, they have to prove that they are who they say they are. That's usually going to be the DL, the driver's license, the passport, things like that. And part of the reason is that they have to prove who they are as they're purchasing it, because we also want to make sure they don't have any, creditors following them and things like that. But they also going to have to prove later on when they're going to disgorge themselves of the property that they are that same person. So again, they can purchase the property, have no title insurance, take title in the name of Mickey Mouse. But boy, when they go to sell the property, they're going to have to prove that they're Mickey Mouse. So it's going to be, I don't know, maybe that'll be easy. I don't know. So how do you want your name to appear on title is the way you want to ask the question. And then I usually ask the client, what does your driver's license say? We have one right now where the seller is having to change their name. And so remember that it has to be consistent with the lender's information. So anytime you see, Bob or, some other, Rick, so the question really is going to be, I get that's your common name, but what is your legal name? Okay, so that has to be consistent with the lender's information, because the lender is going to come back and if your contract is not consistent with their proof of who they are, and the lender has already verified it, because the lender's doing the pre-approval, doing all that stuff based on their name as it appears on the credit report, et cetera, which will be their legal name. Okay, so that's going to be important. It's got to be consistent. And if it isn't, the lender's going to probably have you redraft your purchase agreement. And we don't want to have to do that. It's too much work. You may have to redraft the purchase agreement between the parties. And again, that's not applicable to cash transactions, but title insurance, again, as I said earlier, is not legally required in California. The courts have held that it's readily available, fairly inexpensive, easy to obtain, and it just makes good business sense. So title insurance, I would recommend. Okay, all right. They are going to have to, even though it's not applicable to cash transactions, they're still going to have to prove who they are upon sale. So, it's going to be one of those things where, maybe it's cute to buy it in some, other name, but maybe not a good idea. So why the process? And why is this important? So the purchase agreement calls for it. Receipt by the parties is confirmed and time-stamped. And again, this is the preliminary title report. So let's go to the beginning. And so I want to talk about Easton, the Easton case, Easton versus Strasburger. And so, prior to the Easton case, and again, this was a Court of Appeals, a 1984 decision. I'm going to actually show you the decision. But prior to Easton, it was kind of the Wild West in California. And so, we got some issues, and Easton we're going to talk about more in terms of the as I'm looking for it here. I'm going to talk about more in terms of what started everything and started our obligations at law for what we have to do. So I have the Easton case here, and again, this is the California appellate level. So this is a case that went from the lower court, and it went to the appellate court, and it became the law of the land. It became the basis behind California Civil Code 2079, which is the civil code that regulates you and I in our real estate practice, things like that. And so I've highlighted some of the relevant parts. Easton was the purchaser and the respondent at the appellate level. So they were the buyer. Strasburger was the seller. But then there was also H.M. Bull, which I actually know H.M. Bull. It was First District, Division 2. Not that that's important. And the appellate decision came about in 1984. Okay, so an appropriate year, right? So here's the attorneys for the case if this matters to you. And again, folks, I will send all this to you. If you want it, just send me an email. I'm more than happy to send it to you. Interestingly enough, no appearance for the defendants, cross defendants, and respondents. Et cetera, et cetera. So what is the opinion of the court? The opinion of the court, Valley of California, Inc., which was the real estate company, appeals from the judgment. There were many parts to this case, but we're going to talk about how it related to the real estate company. So appeals from a judgment for negligence entered in favor of the purchaser, Easton. The appellant was one of 6 defendants in the action, which was brought by the respondent for fraud, which is actually should be fraud is intentional misrepresentation. But fraud was the original, and then negligent was included, and then negligence in the sale of residential property. So I'm not going to go through all the facts of the case, but you can kind of take my word for it. There was a land failure at the property back in 1973. This is not I highlighted a lot of other things in a different version of this, but the seller was aware of the failure. The buyer was not aware of the failure. The agents were not told by the seller of the failure, but the agents had reason to believe that there was a problem. I mean, there was netting on the ground, there were things like that, and so they just chose to ignore it. And again, at that time, we didn't have, transfer disclosure statements and things like that. So at that time, it was pretty much buyer beware. Now that has changed significantly since that time. And so again, remember that the real estate agents had reason to believe, from ordinary observation, that there was a problem with the land and the property. And of course, you can figure that after the buyer purchases the home, all of a sudden there's a big failure. Right. And so they had all kinds of witnesses, expert witnesses come in. Negligence was apportioned among the parties. But it turned out that according to some people, that some of the evidence was that the property was, it would cost more money than they paid for the property to fix it. So, I mean, the purchase was like around 170 something thousand, but the damages were going to be clearly up into 200 and something $1,000. So again, throwing this out at you here, you can read it when you're ready to read it. It's a good case. It's in my opinion, my humble non-legal opinion. But notice here it elevates a broker's duty beyond the level established by case law, and that's one of the deciding factors in the case. And so let's I think I have some other bullet points in here. I guess maybe I didn't. I grabbed the wrong one. This is the one that doesn't have all of my highlights. So real estate brokers are often in a very commanding position with respect to both sellers and buyers of residential property. The real estate broker's relationships to the buyer is such that the buyer usually expects the broker to protect their interests. This trust and confidence derives from the potential value of the broker's service. Houses are infrequently purchased. In other words, we don't buy them every day, and require a trained eye to develop to determine value and fitness. And so we'll see some key words coming out of this case that end up changing our business. So, for example, think about your transfer disclosure statement for a second. The agent has an obligation to do a reasonably competent, diligent, and visual inspection of the accessible areas of the property and to report on those same. And again, material facts affecting the value and desirability of the property. And so we'll see this language in this case. It'll come right out. So here we go. Definition of the broker's duty to disclose as necessarily including the responsibility to conduct a reasonable investigation, thus seems to us warranted. And so again, you see that every day when you look at your transfer disclosure statement. You see it every day when you look at your Avid. This case just changed the way that we did business. So again, I don't want to spend a lot of time on this because the next case is really the one that's going to really be in there. But the Lynx case was, what started the whole process, and then Easton came along and started to heighten the duty of the seller of the property, and then obviously for us with the agents as well. And so let me scroll past here, and I think I've covered most all the salient points on this one. Again, I think it's a pretty good case. I mean, they quote all kinds of other cases and other precedences, things like that. But I think you get the gist of what we're doing. So essentially, the brokerage firm was held responsible partially for the damages to the new owner's interest in the property. Okay, so that being said, that was quick. We managed to get through that really fast. Let's go back to our PowerPoint. So again, so we took a quick look at Easton. You have a good idea what that looks like. Now let's take a look at the Field case. And the Field case again was California Court of Appeals. I couldn't resist. I love this case. I mean, it's a mess. And obviously we want to get into a conversation about it, read the preliminary title report, but this is one of the reasons why this is so important. So, we're going to close out on Easton, and we're going to go into the Field case here really quick. And the Field case came out of Otay Mesa, the Otay Mesa Water District. So obviously very personal to us here in San Diego. Century 21 Cloud and Furness was the defendant in this case. And again, I'm not here to pick at people or to find fault or blame with anybody. But this was a case that came in much later, the 1984 case. Now we have Field, and we have other cases since that time. I've got a pretty good running analogy or chronology of those things. And so, but this came out of, this again was, and I'm familiar with these attorneys, I know them well. But this one was certified for partial publication, and this was the one that became a problem for us as real estate agents. And so the case itself was really, as you can see on your screen, was really a statute of limitations case. So the Civil Code 2079, again, which came out of Easton, right? Remember the Easton case? So it came out of Easton. So Civil Code 2079 requires that there's a 2-year statute of limitations to bring suit against the brokers. The court held that it doesn't apply to claims for a breach of fiduciary duty, where they exclusively represent the buyers. And again, whether you agree with the opinion or not, it wasn't the opinion that was the problem, it was the dicta. And the dicta is the language by the judge who wrote the opinion on what should and shouldn't have happened. So I think when we go through the case, you'll probably agree with the outcome. But again, the problem for us is that the dicta ultimately essentially became the law. And so it kind of turned us on our head because we don't have an obligation to investigate the title report. We don't have an obligation to give legal advice to people. And in the past, we would just give them the title report and we would say, here, let us know if you have any questions. Today I would recommend that you go over the title report with your buyer, but we're going to see some facts in this case, which is going to preclude that from happening. Okay. Everybody good so far? All right. So they purchased a residential property, Shirley Hayes, and I'm pretty sure she's still licensed and still doing real estate. Worked with the buyer, exclusively with the buyer. The buyer won at the lower court. Robert and Betty Field won at the lower court. Then they come up to the appellate court, and of course, if you know anything about the legal process, you got a lot of money into these cases. I represented a brokerage in up in Irvine where they had millions of dollars in attorney's fees. This is at the lower court before they even got to me, and then I was the closer, right? The relief pitcher, the Trevor Hoffman. I've been told that that's been a long time since he was our relief pitcher in San Diego, but that's a lot of money. And so by the time you get through that, then you're going to go up to the appellate court. Now you're really sinking some coin into this, and most everybody gives up by that point. And so anyway, purchase of a rural residential property. We conclude, so this is the court saying, we conclude actions by the buyers against the brokers who exclusively represent them in real estate purchase transactions are not limited by the 2-year time bar. So again, it's a statute of limitations case. But again, we're going to see why the language of the court, of the judge, is so damning for us. And so it's anyway, fiduciary duty of the broker, again, who contracts to exclusively represent a purchaser of real property to investigate first time, is independent of the separate obligation imposed on a seller's broker to conduct a reasonable visual inspection of the marketed property for a buyer's protection, as announced in Easton. And so the Easton case kind of leads all of this, all right? And so the court held, they agreed with the judgment, they affirmed. So here we've got the buyer buying this property. This is in 1992. They sued their agent over a transaction that occurred in 1988, so literally 4 years after Easton was decided. And so they had all these other stuff. So the statutory duty, by failing to conduct a reasonably competent, diligent visual inspection on their behalf, and also had falsely represented the residents' physical condition. So that being said, the third amended complaint, they had to rewrite it 3 times, right? So Century 21's failure to inspect related title documents and determine the scope of an easement in favor of the Otay Water District. And this is where this is going to go. And this is why when we have our conversation here coming up on how to read the prelim, you're going to see how this could have been avoided in a very big way. So the defendant real estate company falsely represented that Otay had an easement only for use of the driveway, although in fact the easement prevented them from exclusively using a major portion of their property. So it's going to turn around. The whole case is going to turn on the fact that the easement was far more extensive than had been represented, and the agent made the assertion that it was nothing, don't worry about it. And I think you know as well as I do, anytime somebody says don't worry, it's nothing, don't worry about it, that's what I'm worrying about. Okay. It included the right to spill water onto the field's land. So again, picture Otay Mesa, big water tank up on top of the adjoining property. The easement that was in the title report said that they could dump the bilges, Navy term, at any time, and it would flood the property of the field. Now imagine that you find out that that can happen, and we're going to see why it's even worse, because they didn't receive the preliminary title report till after closing. Now I know that we're all taught, and you probably have that same experience, that it's we need to make sure that you get that prelim in there, you got 5 days, all that kind of stuff. But this puppy closed without having that title report even show up. So after they get the title report, of course, then they read it and they find out that Otay Water District can flood their property. By the way, flood the residents as well. So including some area occupied by the residents. Okay, so buyer's agent was aware, but neither verified the extent of the easement or the represented acreage of the property, nor did she advise the buyer to do so. She implied that both the acreage and the extent of easement were erroneously represented. So, and who's to trust? You figure you got to trust your real estate agent. That was clearly the message sent by the court. They had a right to trust it. The buyer would have done more investigations, except that the agent represented that it would be a waste of money, waste of time. So she didn't even receive the title, the report until after escrow had closed. The court held that she breached her fiduciary relationship with the buyer by not reviewing the prelim before the close of escrow to verify, among other things, the scope of the easement revealed in the TDS. So even the TDS said that that there was an easement by the Otay Water District. Okay, so should have consulted with a TO. Okay, here's my title officer, remember, to review the title report before the closing and to explain and plot the easement. So how many times have you heard me say that whenever you do a real estate transaction, you always want to get several things, and I'm going to talk about it in my PowerPoint. So you want to get a property profile, you want to get sold comps, you want to get any recorded documents, right? So notices of default, things like that. Easements, not the full extent of a prelim, but you want to get that information. And then finally, you want to have the title company blow up the plat map and plot and color code the easements. Okay. And I say this in every class I teach, and here it is: explain and plot the easements. Okay, and so I want them to blow up the map so I can read it, not this little thing like this that I can hardly see. And I got I'm blowing 2019 vision, so and I have trouble reading it, then it's tough. Okay, and here's my 2079 statute of limitations, which comes out of Easton. And so what does it say? 2079 says conduct a reasonably competent, diligent visual inspection of the property and disclose all material facts such an investigation would reveal to a prospective buyer. And again, statute of limitations issue. So the section 29 came about because of Easton. Remember Easton? What a great case, right? Seller's broker must diligently inspect residential property and disclose material facts they obtained from that investigation. And in this case, the seller's brokers are chargeable with knowledge they should have known had they conducted that adequate investigation. But it's not going to be about the seller's agent. In this case, what we're talking about here is going to be the buyer's agent. Okay, so a selling broker, that's the buyer's broker, has no obligation to purchasers to investigate public records or permits pertaining to title or use of the property. But we're going to see here lies the rub. So 2079 states the inspection required does not include or involve an inspection of areas that are reasonably and normally inaccessible to such an inspection, nor an affirmative inspection of areas off the site. As you know, you don't have to inspect condo, common areas and things like that, or public records or permits concerning the title or use of the property. Okay, now again, this is the rule now from 1992, right, or 1998, right? So we're gonna see that there have been some changes to the law even since that time. So the statute of limitations for actions is usually normally triggered on the date that the plaintiff discovers or should have discovered the negligence. We'll go down a little bit further. Agent's duty to disclose material information to principal includes the duty to disclose reasonably obtainable material information. The fact that a broker must learn and the advice that and counsel required of the broker depend on the facts of each transaction, of course, the knowledge and experience of the principal, the buyer, the questions asked by the principal, the buyer, and the nature of the property and the terms of sale. The broker must place themselves in the position of the principal, right? Put yourself in their shoes and ask themselves the type of information required of the principal to make a well-informed decision. This obligation requires investigation of facts not known to the agent and disclosure of all material facts that might be reasonably discovered. And again, in this case, the agent made representations that were inconsistent with the facts of the property. And so this is going to fall under that category where they said something that I don't know, do we know that they knew and they intentionally deceived the buyer? I'm not so sure. I can't answer that question. But at the end of the day, the buyer ended up suffering quite a bit of a harm. Okay, so anyway, the Supreme Court, this went up to the Supreme Court in 1998, and they denied. They said, "Nah, you guys are done. You've done everything you need to do." And so that was the end of the case. So the other named defendants, okay, later settled with the Fields. The Fields belatedly discovered that Otay Water District owned part of the land which had been represented as belonging to the seller. So when they were buying the property, they were told, you own all of this. Okay, so this is my classic you own to the fence, right? And so I've had a couple of cases on that where the buyer was told that they owned property to the fence. I always say that fences make good neighbors, but they don't make good property boundaries. And so I frequently get cases where the fence is not the property boundary. And I always tell people the people that put the fence in are not surveyors. They're just following an instruction, put this one here, and then join the two. But it may not be a straight line. There may be a lot of other factors involved in it. So again, good fences make good neighbors. They don't necessarily make good property boundaries. Okay. So in this case, they discovered that, in fact, the property that they thought was theirs, part of it was actually owned by the Otay Water District. And so, the size of the land, obviously not as big as it had been represented to them. And then finally, the easement was not as represented to them. The easement was represented as being not as extensive as it was. Are there any questions so far? Okay, all right, seeing none. The Fields did not pursue an intentional misrepresentation case at trial, but that's going to be, I think that's going to be the majority of what we're going to talk about. Yeah, it is. Okay, so that's pretty much the majority of that case, and that's, again, that is the Field case. And so I'm just always proud of the fact that I actually have you on the right screen back there. So interesting case. Again, it was a statute of limitations case. Unfortunately, the judge's opinion was not very kind to Shirley Hayes. And so as a result of that opinion, we end up with actually a case that changes the way we do real estate business. And so I always tell you, don't go down and pull permits. If you look at the myriad of pre-printed disclosures that come to you from the California Association of Real Estate, it's an amazing amount of stuff, a lot of which is included actually in your Avid. If you look at the bottom of page 1 of your Avid, I frequently go into trial and they'll have, that up on the board in, excuse me, in 10-inch letters. That the seller's obligation of disclosure and the agent's obligation of inspection do not replace the buyer's obligation to investigate the property. So those are my 3 duties, right? So I have a seller's duty to disclose what they knew or should have known. The agent's duty is to conduct a reasonably competent, diligent visual inspection of the accessible areas of the property. And the buyer's obligation at law is to investigate. And you don't ever want to interfere with that. I have stuff going to trial now where the buyers were prevented from actually doing their investigations. Okay. All right. So that's a Field case. So when do you have to transmit the preliminary title report to the parties? And again, I'm risk management. That's my big thing. Immediately upon receipt. So if you get it, then chances are good that the buyer also got it. We want the buyer to get it, the seller to get it, all the agents to get it. Everybody gets it. It's all time stamped. And so if you get it and the buyer doesn't have it, you immediately push it over to the buyer and you say, let's talk about this. Okay. All right. So immediately upon receipt, the seller gets it. They get an opportunity to see what is in there. They probably don't even know half the stuff that's in there. And then it gives the seller's agent an opportunity to go over that preliminary title report with their seller. These are the things that you're going to have to clear up, loans and encumbrances and things like that. And we're gonna go deep into this. So do we have an obligation to review it with the parties? And I'm going to tell you immediately upon receipt. So we do have an obligation to go over it, even though we can't give legal advice, and I get that. But the fact of the matter is that we have to understand how to explain it, and hence that's what we're here to do today. So again, the Field case, right? Bad news. All right. So there are, most importantly, Schedule A's and Schedule B's. And so those are the 2 that are going to be contained in what we're going to talk about here today. Now, as a general rule, most of the lawsuits are in the Schedule B's. Okay. And so I'm going to tell you today, I'm going to show you how to hopefully avoid that. I like the preliminary title report. I think it does good stuff. And so, but we got to know how to read it. Okay. So how does the licensee protect themselves, their clients? Obviously, this presentation, that's what we're going to talk about. So quite simply, prior to the beginning of representing a property, okay, whether you are representing the seller as the seller's agent or the buyer as the buyer's agent, you want to order a property profile. Again, this is my list: property profile, sold comps, because title's going to have what your MLS doesn't have. Now, there are also other programs. So the MLS will only have those transactions that are closed as a result of that were input into the multiple listing service. That's not enough. In the old days, we would contact the title company, we would get the sold comps, we would hold the two up to the light, and then hopefully come up with what we thought was a value of the property. But the title, from the county recorder's office, is also going to hold things that are not important to us. So, for example, interfamily transfers, death deeds, things like that aren't necessarily going to be important to us. But at the end of the day, we got to come up with values. So there's some really good programs out there that will do that for you. The RPR, for example, the Realtor Property Resource, does a great job. It mines 300 data sources, including for sale by owners. Tends to be a pretty good determinant of what the value is going to be. I've rarely seen it off more than $50,000. So interesting enough, I use it in my trial work. To determine the value of property. I use a lot of different things, and that's one of the things that I do use. So the third thing I always get is any recorded documents. We're going to see how important that is in a minute. But a recorded document is something that was important enough that whoever recorded the document, again, the document has to have the legal description of the property, was taken down to the county recorder's office and recorded. And so what are those kinds of things that we're going to see? And we'll see these when I pull the document up. But remember that the reason that we put them down at the county recorder's office is that it's a principle of law called in rem jurisdiction, which means it has to be where the thing is. So it has to be where the property is. And why do we do it that way? Because it sets a standard that if anybody wants to know anything about a particular property in that county, then they know to go to the county recorder's office and they will find it there. Now that will cover the property. So that's my constructive notice. So as opposed to actual notice, that's my constructive notice about things that are inherent about the property. Okay. So I know I'm pretty confident if I want to go look up my house, I can go down to, I can log into the county record and I can pull up all the documents, everything that is relevant to my ownership of that property. Okay. And the same thing holds true for liens, banks giving loans, IRS, all these things, so we have general liens and we have specific liens, but obviously specific liens on the subject property. The title company will usually order an SI, a statement of identity or statement of information from all the parties to get further information from the more general liens versus the specific liens. But when I go into the county record, again, this is a year of law school, so I'm not going to be able to encapsulate it all into one hour and a half, 2 hour session. So just be aware, any recorded documents, those are the things I'm looking for. Now, clearly in the prelim for the field case, it was a recorded document, and I'm going to show you what it looked like. And that was back at a time when they would reference the document. It would say, reference such and such a document for further particulars. And so anytime you see something like that, you need to get that document. And so in the older days, we would have to call the title company and ask them to pull the Schedule Bs. Remember, all the lawsuits are in the Schedule Bs. And so we would ask them to pull them so we could look at those Schedule Bs. And among those was this easement by Otay Water District that they could pump the bilges and essentially flood the subject property. Okay. All right. So any recorded document, that's what we're looking for. Okay. So again, I said earlier, blow up the plat map, plot, color code the easements, all of the easements, and that's a very important thing. And I'm going to show you why in a second. So let's take a look at a sample preliminary title report. Okay. So this is what I want to do. All right. I'm going to go ahead. I'm going to switch screens and we're going to go over here to an actual preliminary title report. I'm going to close out the field case. I wanted to make one comment because earlier I said you never want to ask them how they want to take title of property. You always want to ask, how do you want your name to appear on title? There are plenty of documents. And again, the title is a legal industry, and it changes. So this is a report that was sent to me by a particular title company. I think it's actually a pretty good one. And again, if you want it, I'll send it to you. I would look to find something perhaps a little bit more current. But notice I have my tenancy in common. I've got my joint tenants. Joint tenancy was typically joint tenancy with right of survivorship, WROS, with right of survivorship. That's what we used to call it. And so it was kind of akin only to joint tenancy. Well, now we have tenancy in common with right of survivorship. And so, that law has changed. And so you can see there's a pretty good breakdown of what is what. So in all four of the types that we have here we have community property with right of survivorship, right? In all four of them, the equal right of possession. Okay, so not to go into a great big long thing here, but again, I will send this to you. Now we have deeds on death in California. So again, I think this is pretty good, does a good job of representing what it is. And again, this is from 2022. Okay, everybody okay with that? All right, let's go to, he says with confidence, let's, oh, wait a minute, I'm on that page. Okay, so hang on a second here. We're going to cancel that. I'm going to skip over the tax bill for a minute, other than the fact that I want to tease you a little bit by telling you I've never seen a property that doesn't have a special or doesn't have an assessment on it. So, well, we'll come back to that. So let's take a look. We're going to look at a preliminary title report, and we're going to look at an example that I've already gone through, and I've highlighted the key elements and things like that that are going to take up a bit of the rest of our time here together. But again, some of the stuff I've already told you. Preliminary report, also known as a title commitment in some areas, is a dated formal report. It sets out the conditions of the policy that would be issued on a particular parcel of land. They don't care about the building so much. Purposes to facilitate the issuance of a policy. So once again, it is not a title policy. A preliminary report is preliminary to the issuance of a title policy. Everybody okay with that? Any questions on any of that so far? Okay, so we're going to dig in here. Obviously, exceptions in a policy, matters of record, things like that. We know everything about the property really needs to have been recorded. I frequently get asked the question, what happens if there is no title insurance? Well, so the transaction occurs between the buyer and the seller. I had a case where the half brothers owned a piece of land, and the one half brother sold their interest in the property for money to their other half brother, and I think the exchange was like for $125,000. No title insurance. They're half brothers. Everybody's figuring, hey, everything's cool. Well, it turns out there was a $75,000 tax lien on the property, and so the person that paid the 125 now also had an additional $75,000 tax lien. So essentially the property, that was a significant portion of the property, would have been discovered, by the way, by a title company. A title search would have discovered that. Okay. Again, a general lien by the IRS, and that they would have issued a statement of identity, would have run credit, they would have done all kinds of stuff, and they would have found that information out. Okay. So essentially matters of record. So what is of record? So title wants to only insure those things that you can pin on them, not stuff that you haven't done. So what happens in the event where and this is we'll talk about the concept of a bona fide purchaser for value. So you have a buyer who purchases a property and from a seller and no title insurance. Okay, they pay cash. This is why I tell you, don't ever tell your client not to get title insurance. So they buy the property, they pay cash, and so the buyer now has the grant deed being the highest form of deed, right? And so it's an insured document versus a quitclaim, which is the lowest form of deed, which is typically uninsured. And so then remember what we talked about, where there wasn't insurance in a transaction. Now there's a gap in that policies, what will later become a gap in the insurance policy. So buyer buys the property, they get the grant deed, they take the grant deed. What should they do with the grant deed? If there was the loan involved, a lender involved, they would require it to be recorded, right? Okay, title insurance and recordation. Well, does the buyer have to record the grant deed? And the answer is no. The buyer doesn't have to record the grant deed, but should they? And the answer to that is clearly yes. Why? Because they want to protect themselves from other claims against the property, whether they have title insurance or not. If they don't have title insurance, they don't have to record the grant deed, but I think that's a big mistake. So, what happens? Buyer takes the grant deed, they throw it in a drawer. Okay, do they own the property? The answer is yes, right? They have a grant deed, they paid value for it, the whole thing. Along comes another buyer after this buyer throws the grant deed in the drawer, and another buyer comes along, unbeknownst to them that there was a previous sale. The seller then again sells to the new buyer, and the same property, right? And so the new buyer gets a grant deed. And so what? So now we have two owners of the property. And so, I know everybody's thinking who sues who, right? Well, the answer is really that the seller is the one that'll be involved in the lawsuit, right? Because they've essentially sold the property to two different people. But buyer number two goes down and records the grant deed. And so what happens then? Well, again, buyer number two now has evidence and has given constructive notice to the world by recording the document that they own the property. So, but what about buyer number one? Buyer number one comes back and says, no, wait a minute, you can't do that because I already own the property. Here's my grant deed. Buyer number two says, I'm a bona fide purchaser for value. So a bona fide purchaser, BPV, bona fide purchaser for value, which means I paid value. I was unaware of the fact that this property had been sold to you or anybody else for that matter. I paid market value for it. And so I'm an innocent purchaser. And you know what? Buyer number two may end up with the title of the property. Okay, so both of them have the grant deed, but now the question is, what does the buyer number one do? So buyer number one, of course, is going to litigate against the seller who should not have resold the property to another buyer. But again, buyer number one's got some contributory negligence to this by not recording their grant deed. And so everybody's going to be involved in a lawsuit. And this is why we really like title insurance. Okay, all right. So that being said, so the matters shown in the report are as follows, okay? And so we're going to talk about the estate or the interest. Those are usually my Schedule A's. The record owner of the property, so that I know I have that part right. And that's going to be very important when we write our offer, because we need to make sure that we actually have the name of the seller properly when we do the offer. I just had a conversation with a flipper the other day, and they were so proud of the fact that they've got hundreds of offers out. And they sent an offer into one of our sellers, and it said owner's name was matter of record. It could have been on file. It could have been a lot of different things, but their thing said matter of record. So I called them on the phone and I said, that's not going to work because that creates an ambiguity in the contract. And so therefore it could be held to be unenforceable. And so they said, well, but wait a minute, we've got hundreds of these out. And I said, good for you. But at the end of the day, the contract is what the parties think it is. And so you're probably going to end up, if you have a problem, if you have a claim against the transaction or the seller decides not to do the sale, you don't have the seller's name. Now, obviously, they're doing it for expedience purposes because they want to be flying these offers out and they don't want to have to keep looking up the seller's name and stuff like that. Well, you haven't created a contract with the seller. So that's part of the problem, and it unwinds into being a very big deal. So when we do a transaction, we write the offer, but we look up the grant deed. Linda specifically, our broker, goes in and looks up the grant deed of the property to find out how is title actually held to the property. And so that's a copy paste onto the purchase agreement, so that we know that we have committed our buyer to a contract with the actual seller of the property. And so this is one of the reasons we don't worry about liability quite as much as others do. And that's because we're pretty thorough about the way that we write our offers. Is everybody okay with that? Is that good? Okay. So anyway, legal description. This is again Schedule A, liens, encumbrances, and other matters which affect the title, the date, and time of the report. Now we're going to get into Schedule B's. Okay, so CLTA, normally limited to the public record, no reference to off-record matters. They don't have an obligation to do more research than what they can get from the county recorder's office. That's what they're going to insure against. Is everybody okay for that? So let's go ahead. We're going to scroll down a little bit, and thank you to Fidelity. They gave me this report. I should probably see if others have one that I like better, but this one's actually pretty good. So this is what my preliminary title report looks like. So starting off, and this is very common with almost all of them. And remember, there's really only a couple of title insurance companies out there. The rest of them are just, they just get their stuff from that title insurance company. So on the left-hand side, I usually have the name of the escrow company, as well as the name of the escrow officer. And then I have the escrow number. That's the highlight part that I put over there. On the right-hand side, I have the file number, which is the file number that the title company uses. Whenever I call into the TO, in this case, John Doe, the title officer, I call into the title officer, and they don't want to hear street address. They want to hear either their file number, which is preferred, or the APN number, the assessor's parcel number of the property, which is essentially the thumbprint, of the property itself. Okay, so property address, again, I want to make sure we're very clear about this. The property address is really for accommodation purposes. The property address does not create the contract. The contract is created by the title, the legal description of the property. The deed transfer has nothing to do with the street address at all. So when I'm looking at this, I'm realizing that I've got a street address, but that's really just because that's what we understand, right, as normal folks. Okay, all right. So I get down to my preliminary title report. So here, look at this key information, dated. They're almost all going to say 7:30 a.m. Why? Because they have researched the title up until 5 o'clock the night before, and they are going to come up with their report that they're willing to issue a policy against based on what we have right now. So again, there is no policy, but based on what we've researched up until 7:30 in the morning, right? We get there bright and early at the title plant. This is what we're prepared to do. Okay, and so again, you see you can see that actually you can see that pretty good. So date and time up to which matters affecting the title have been examined and reported, referred to as the plant date. Okay, this is not the title date. All right, and so this is the plant date. Okay, there's no test on any of this. You don't have to worry about it. Then we have they're prepared to issue or cause to be issued as of that date. Ensuring against losses may be sustained by any of these things and clearly if they make a mistake. Okay, so that's why they come up with all this stuff. They say, oh, well, we got this. It's kind of like a physical inspector, but not of the structure, but of, in fact, the title of the property. And so they're going to put in there, here's all the stuff that we found that's bad. If we missed anything, it's on us. But chances are pretty good we didn't miss anything. Okay, all right. So printed exceptions and exclusions, and that's the boilerplate language that are in there, are set forth in Exhibit B. All arbitrable matters shall be arbitrated at the option of either, et cetera, et cetera. And again, I will send all this to you. Down here, this report and any supplements, if it is desired that liability be assumed prior to the issuance of a policy, remember what I said, a binder or a commitment should be requested. So again, if you want that policy, I just sold a property up in Malibu, and the buyers in the middle of the transaction said, when do we get the title insurance? We want to make sure we're getting that. Well, what you got was the preliminary title report, which told you this is what it looks like at this point. If you close today, we're prepared to insure this. And sure enough, 30 days after closing, they did get their title insurance policy. It's no longer prelim, by the way. Remember, prelim is only preliminary to the actual policy being issued. Okay, so exceptions and exclusions are meant to provide you with notice of matters which are not covered under the terms of the title insurance policy and should be carefully considered. And we're going to take a look at some of those. So here we are. We're in our Schedule A's. Okay, so it's just fascinating to me. It takes me an hour to lay out the groundwork. But anyway, so and this is in most all of them, right? The estate or interest in the land hereinafter described or referred to as covered by this report is a fee. So remember, we have fee determinables, fee simples, we have all this. Fee is the highest form of estate. Okay, and so that's the one we want. So here, it says right here, a fee is the highest type of estate or interest an owner can have in land, one freely transferable and inheritable, and whose owner is entitled to possession. There are a number of other estates or interests, and that's why I mentioned a couple of those already. We don't need that. If you got a fee estate, then you're in pretty good shape. Okay, so a freehold estate, right? So what's less than a freehold estate? Well, that would be a lease. right? So a leasehold interest would be a less than freehold estate. So, these are terms, I mean, in normal language, do you have a normal conversation with somebody covering these things? Chances are pretty good you don't. Okay, but that's what they are. And so here again, title to that estate, and this is all in the Schedule A's now, is vested in an LLC. And so the owner of the property currently is a limited liability company. So it happens to be 1234 State Street LLC, a California limited title company liability. Why is it important that it's a California limited? Because it's considered a domestic corporation, okay, versus so for example, we have a brokerage in California. We are a domestic corporation. We're an S corp in California. We're a domestic corporation. We also have brokerages in Idaho and in Virginia. And in those places, we're considered a foreign corporation, even though we're U.S. citizens, we're doing all the U.S. stuff. But the fact that it's not a corporation that was originally created in that state means that we are a foreign corporation in those states. We are a domestic corporation in California. Everybody good? Okay. The land referred to in this place is described as follows, and now we're going to send you to Exhibit A within the Schedule A. So remember, the Schedule A is always about the property and the ownership of the property. Okay, so made here in a part 2. So let's see if I can speed this up a little bit. So here is my legal description of the property, lot 6 of tract 3103, as shown by map on file in book 288. We're going to look at the map in a minute. Okay, pages 52 through 54, records of any county, California. Okay, all right, so that is the legal description of the property covered by this report. Clearly not the street address, okay? Then I have my assessor's parcel number. And so this is for reference purposes. Number assigned to your property by the county tax assessor. It's the location of the parcel of land by book, page, and parcel numbers. So 123, the first 3 numbers, refers to the book. 456 refers to the page block, and 78 refers to the actual parcel number. So when I get down to that map, and I'm not going to flip down to it, it'll disrupt what we're doing, but I'm looking for that 78, right? Because that's going to tell me that that's the property that is owned that is contemplated by this transaction. Everybody good so far? All good? Now we've got our Schedule B, Section A. So we're past, again, Schedule A, pretty simple, right? I mean, it's really about the property, about the current ownership of the property, but Schedule B is where the fun begins, okay? So let's take a look at my Schedule Bs. And so the exceptions in the policy, and this is just a general statement, taxes or assessments that are not shown, excuse me, is going to be an exception. Proceedings by a public agency that may result in taxes or assessments or notices of such proceedings, et cetera, et cetera. Any facts, rights, interests, or claims that are not shown by the public record, but that could be ascertained by an inspection of the land, or that may be asserted by persons in possession of the land, chances of them going out there are pretty small. Although I do like to have them do a survey for me, and they usually do that for free. Okay, so what do? They don't do a survey. It's not a they don't use a sextant and stuff, but they'll go back out and they'll walk the property, that kind of thing. Easements, liens, or encumbrances or claims thereof not shown by the public record, right? That's going to be an exception. Okay, so they don't want to be held to that stuff if it's not in the public record. Why? Because they have no way of knowing that it's there. All right, it's not in the county where the property is, no in rem jurisdiction. So any encroachment, easement violation, variance, et cetera, affect that would be disclosed by an accurate and complete land survey, which they're not going to do. So it's an exception. Okay, unpatented mining rights, et cetera. Any lien or right to a lien for services, labor, or material not shown by the public record, those are the kinds of things. So these exceptions do not appear in the ALTA policy. All right. So these are called the Western Region exceptions. All right. If any policy to be issued in the standard coverage format, these items will appear in Schedule B as exceptions. These exceptions don't appear in the ALTA policy. Okay. All right. So we like the ALTA policy. It's pretty good. Okay. All right, scrolling down a little bit further, now I'm in my Schedule B, Section B, and so here are my exceptions to coverage. And so the first thing you're always going to see, almost always, I can't remember if I've ever seen anything different, but almost always is my property taxes. And so these are my general property taxes, okay? So including general and special taxes, personal property, if any, so other states have personal property taxes, levied for the year, a lien not yet payable. Okay, so unpaid taxes, they're going to tell us whether they're paid, unpaid, or delinquent. Okay, so number A is going to be my property taxes. B will be my property taxes as well, and this is where they're going to give me my list. And so here I've got my property taxes, my first installment amount is valid until December the 10th. A lot of people think that the taxes are due on December the 10th. No, they're delinquent on December the 11th. They are actually due November the 1st, right? So we all remember that from Real Estate 101 school. Likewise, my April 10th delinquency date is, a March 1 collection date. Okay, so it's due in. It just got to be in that window period of time to get it in there. Otherwise, you're delinquent. And they're very unforgiving about that, by the way. So the postmark, whatever, if it didn't get to them on time, they send it back, and they send it back with a penalty. And my memory is 10%, although I don't have the experience of having too many penalties with my property taxes. I tend to pay them, or I have loans that pay them for me, that kind of thing. Okay, so this gives us some good examples. So first installment after the 10th, excuse me, penalties will apply. The penalty would be $83.30. So there you go, 10%, right? Due with the installment and paid after December the 10th. So they send it back to you. They're not going to cash the check. They send it back and they say, send us the money, but add the $83.34. Okay, and then we'll accept it, assuming you get it in before the next installment is due, which is in April. And there's the penalty in April is going to be higher than the penalty that was in December, and that's going to be $93.34. And so then they're going to break it down to my land value, my improvement value. So my land value is what the county has assessed that the land is worth. The structure on the property they've assessed, the improvement value they think is $148,000. Okay, now that is not necessarily the value of the property, and if you've owned property before or any shape or form, you know that your appraised value is very different than your assessed valuation. Okay, everybody good with that? So I often tell my clients, they go, "Oh my God, I'm overpaying for the property." I go, "What do you mean?" They say, "Well, it shows the land value and the improvement value are essentially here. What they're going to be $255,000, the total value, and I'm paying $450,000." And it's like, well, yeah, I know, but this is what the county sees the property worth. And oh, by the way, that's going to change, because when you purchase the property, it's called an ad valorem tax. They're going to reassess the value of the property based on what you paid for it. And so your taxes are going to be very different. It's going to be based on whatever you paid for the property. Of course, then you still have to fight the client. They're thinking that that this is the value of their property, and it's not. This is just this is based on what the seller paid for the property when they bought it. Does that make sense? They do the math, they do all these crazy little things. Okay, my exemption, my 7,000, my homeowner's exemption, you actually physically have to file for that. All kinds of people send you things, and most of it is hokey. But you would fill out the exemption and you would send that back to the county. All that really does is protect you from the top $7,000 from creditors coming after you for that. Essentially you get something if the property is taken away from you. So that kind of thing. Code area, assessment number, we've already covered that. We're going to cover that deeper later. Supplemental or escaped assessments of property taxes. So this is an important thing. All right, so what is the supplemental tax? So the supplemental tax is a tax that occurs. So for example, let's take this situation. So the seller is selling the property. The seller bought the property 30 days ago. So they essentially are doing a flip, right? So this is real important because your buyer is going to freak. So the buyer will get a bill, and it'll be usually 30 days after closing. The county will be catching up with the amount of money that they want to assess on the property based on the new value that the buyer is paying for it. Remember that the current taxes are prorated based on what the seller paid for the property. So when the buyer does the prorates, they're just prorating until to make the seller whole, or get to the next tax period. If the seller paid in advance, they refund that to the seller. If there's arrearages, the seller covers that kind of thing. So essentially, the supplemental tax says, well, the seller was paying $100,000 a year in taxes, but because you paid more for the property, you're going to pay $150,000 a year in taxes. So in order to get that even, we're going to assess you the $50,000, send us a check, kind of thing. The difference, that's a supplemental tax, and then after that, you'll be even with how much money you're going to pay based on the value you paid for the property. The seller's interest is gone. All right, you don't get their tax. Okay, so that's the supplemental tax. It's such a big deal that we actually have an SPT form, which is a supplemental property tax form in your zip forms program, but you really don't use it because you use the SBSA, which is the statewide buyer and seller advisory, and it contains that in the document. Okay, everybody good with that? So that's where all that comes from. So my supplemental tax says, and this is what we got to watch out for, is that we're buying a property from a seller who was a buyer less than 30 days ago. They don't even have their supplemental tax yet. And so, at the end of the day, the government always gets their due. So you want to make sure that if it'll say right in the title, we'll see it in a minute, that there have been no transfers of this property within the last 24 months. Well, that's a good thing. But if it was within 2 weeks ago, then we know that there's going to be some problems with that supplemental tax. Everybody good with that? Okay, so from this point on, the items shown in the prelim will normally be shown chronologically by date, and we need to cover those things. This is normal for purposes of title examiner. They're not necessarily in strict order of priority, and that's important. So they're in line with when they were filed, but they are not necessarily in line with priority. Remember, federal tax liens trump everybody, that kind of thing. Okay, all right, so let's scroll down. We're still in Schedule B, Section B, and now we're talking about our covenants, conditions, and restrictions, otherwise known as our CC&Rs. Okay, so pretty much all properties have CC&Rs. I mean, my house is in Del Mar, oceanfront. It's 800 square feet. All day long. It's leaning to one side. It looks like it's going to collapse. Can I build a 16-story high-rise there? Well, I can't, right? Well, I could, but they're going to shut me down before I get past the first story, right? In fact, my poor neighbor got an assessment from the city of Del Mar for paving this little strip of driveway that he had that was just all rocks and tumbles, and he just ran some paver over it so that and they termed that an improvement, and they wanted to tax them on it. They penalized them and all that kind of stuff. And so, these are things you have to deal with. So clearly I won't be able to put a 16-story high rise because there are conditions and covenants and restrictions that prevent me from doing that. Okay. All right. So this document in particular was recorded January 25th of 1969. Okay. So, and so we're always going to have this in there that says that whatever you you should see some of the things. I didn't pull any of these up for you, but references to in San Diego, the title had references to property having ghosts, properties being haunted, things like that. These were in the title, the county recorder's office. Then we had other times where we had references to no Semites may buy property in San Diego. That included Rancho Santa Fe, by the way. So that was an actual restriction on property ownership, which, I think we've done some horrible things to each other over the many decades. And so that we just know that's wrong, inherently wrong. And so we created, rather than going through and cleaning up all of those title records, all those things, we just created one great big statement that says any references to those things are void as a matter of law. So it shall not defeat the lien of any mortgage or deed of trust made in good faith and for value. Okay, so once again, and for value. So those are going to be violations on a number of different levels, clearly fair housing issues. And so we're just going to create one blanket statement that says, anytime you see something like that, we're going to wipe it out. Okay, does that make sense? Kind of an important concept. And so your buyer who comes along and says, well, I don't want to buy a property that says no Semites. And it's like, that's unenforceable. It's void as a matter of law. It says right here that the lender, it doesn't defeat the value, any of those kinds of things. Okay, so because we had that ugly time in our history. Then I get into here to paragraph number 2, and excuse me just a second. Sinuses, sorry. Okay, then we get into number 2, which is an easement. And so remember, we talked about easements and encumbrances. And so an easement is a right to use the land of another. Okay, it is not ownership of the property, it is the right to use. So an easement is for use. As opposed to a license, which a license is personal to one individual, whatever. Limited amount of time can be withdrawn at any time by the giver of the license, the licensor. So, but an easement for these purposes are going to be the local title or local utility company, for example. We got to give them an easement. If the power line goes down and it's the one running across your yard, they have a right to enter to put the power line back up again, whether it's to your property or to the neighborhood. They have a right to go onto the property to do that. Now, normally they give you notice that they're coming, that kind of thing, but it's granted to the utility company. It's recorded in 1969, and I'm looking again chronologically. Remember, this was recorded January 25th of 69. This was recorded in June the 15th of 1969. Okay. All right. Public utilities and incidental purposes. Said land more particularly described therein. Ooh, I hate that. Pull that document. Okay. All right. So it's a right or interest of another party in land which entitles the holder to use the property. I mean, I can tell you there have been some really great court cases from the 40s, believe it or not. And I don't have the time to go through it here, although I do go through it. When I do this class for my attorneys, it's 3.5 hours. So occasionally exact location is not disclosed in the public record. Okay. Number 3 is a deed of trust. And so, as you know, we don't do mortgages in California. We do loans secured by deeds of trust. So that's important because with a mortgage comes foreclosure rights, a judicial foreclosure, in fact. A deed of trust does not have a foreclosure. It has a trustee sale, and otherwise known as a non-judicial foreclosure. So in a mortgage state, in a mortgage theory state, the lender can chase the borrower much easier than they can in a deed of trust state. You know, in California, for example, we have what's called the one action rule, which says that if the bank takes the property back, they've got everything they're going to get, unless they can, of course, prove fraud or anything like that. But in a mortgage state, the bank has to hold on to the property for, in like Florida, for example, 18 months. They hold on to the property for 18 months because the buyer has a right to come back and buy their property back. That's called the right of redemption. And that's only in the mortgage state. But in California, where we're trustee state, you know, we have trust deed. In a mortgage state, you have the mortgagor and the mortgagee. In California, in the trust state, you have the trustor, the trustee, and the beneficiary. Okay, so 3 parties in the trust state, 2 parties in the mortgage state. So in the trust state, I've got a loan amount of $1 million recorded, obviously, on January the 1st of 14, which is really kind of an interesting coincidence because remember, my other stuff was from before that, or I'm sorry, after that. So where are they? Let me pull those up here really quick. Sorry about that. I'm sorry, maybe I was wrong. Okay, 1969. I'm sorry, I was wrong. Okay, so this is put together in 2014. So this is when the deed of trust, again, the loan secured by deeds of trust. It's a year of law school. Don't get too crazy. The trustee is the title company. Frequently, it'll be transferred to the servicer. The trustor is the purchaser of the loan, and then the beneficiary is the bank. And so, in the trust state, the trustee holds the title to the property until the trustor pays it off, and then they get title of the property. In the mortgage state, the buyer actually gets title of the property. So a little bit different. Okay. And again, I teach these classes in all of these different jurisdictions. So there's my loan number. It is an instrument. If I pulled up this document right here, I would see the instrument, the filed document. Trustee has limited powers to reconvey or to foreclose non-judicially different than my mortgage state. Okay, so continuing my Schedule B, Section B, I have another deed of trust, also from 2014 for $40,000. So I have a first. Usually, your first mortgage is a larger number, and then as time goes on, the numbers get smaller. So you can have an unlimited number of loans on the property, but each of the persons that gives the loan is taking risk. So, for example, this is my probably my first deed of trust because it filed on January 1st of 2014 for $1 million. And so on 6 months later, along comes another deed of trust for $40,000. So it's probably my second. Said deed of trust recites that it is subordinate to the deed of trust recorded concurrently therewith. Okay. All right. Now that's 2014. Okay, now I have an abstract of judgment down here. Okay, well, here they talk about the second or junior lien to the deed of trust. Okay, so let's talk about my abstract of judgment. And so my abstract of judgment is going to be, which means that the owner of the property lost in a lawsuit. Okay, and so what does that translate to? So what happens is you lose in a lawsuit, and then in order for the county to understand the loss, the person that won the judgment has to record an abstract. They get an abstract of judgment from the court, which is kind of like a summary of the judgment, and then they attach that to the property. So now this property is not going to sell until that abstract of judgment is paid off. Okay, so that's another encumbrance. I'm starting to add these numbers up because this is for $2,365, including penalty and costs. Okay, so this is the pool company. So the pool company sued, strangely enough, 2011. Now, my memory was 2014. So this was in place before the other judgments were put in there, the other liens were put in there. So I'm kind of surprised by that, right? So court, municipal court, whatever. But this is 2011. So again, they're not in, they're put in order, chronological order, but they're not put in order of priority. Okay. Okay. So it imposes a lien on this and all other real and personal property now owned or hereafter acquired by our group 1234 State Street LLC. Okay. All right. So essentially, it attaches to all the properties, kind of like an IRS tax lien, attaches to everything. Okay. All right. A tax lien. Oops, there's our tax lien. So tax lien for the amount shown in any other amount in favor of the United States of America. Yay. So, the red, white, and blue, the district director of internal revenue. We have a federal number, $345.21. Frequently, that is paying taxes regarding a business, things like that. So again, this was also filed in November of 2011. It just kind of surprises me that the two lenders put their liens in place while these were sitting there prior to them doing that. Okay, federal tax liens become a lien on all property and the rights of property, including real and personal, of the parties that are liable. Okay, so it's a general lien, right? Not a specific lien. Okay. Continuing on, number 7, a lien for the amount shown and any other amounts due in the favor of the state of California. This is usually franchise tax board, usually non-payment of employee taxes, things like that. But we don't know what it is. It's not very specific. I'd have to look at the file number 137894. $320.54 seems like a small enough number. I won't get into how crazy that is, but again, the taxpayer was the 1234 State Street LLC. Okay, all right. Again, 2013. All of these being put on the property prior to the loan being put on the property, which is kind of interesting for me. So a pending court action. So what is a pending court action? So we refer to that as a lis pendens. So I was interviewed by Channel 8 in front of the Plaza in Del Mar when Duke Cunningham had a lis pendens filed against his property in Fairbanks Ranch by the Department of Justice, the big Department of Justice. And so their question to me was, can Duke, whose property was on the market at that time, sell the property? And the answer is sure. You just can't get title insurance. Whenever you have a lis pendens filed against the property, again, it is filed in the county where the property is. It gives notice to the world, constructive notice to the world, that there's a lawsuit pending about this particular subject property. The Department of Justice felt that the property was purchased with ill-gotten gain, that Cunningham was taking kickbacks from contractors bidding for projects within the House Appropriations Committee, et cetera, sold his house on Mercado, sold his house on Mercado. I know the house well. I knew him well. I used to help him pick out videos at Video Vault when it was on the corner of Delmar Heights Road and Mango. But so he sells that house for roughly $750,000 at a time when it was probably worth $350,000. So of course, who was the buyer? Well, it was the contractor was the buyer. Okay, so excuse me, goodness gracious, land of Goshen. Okay, so obviously there was something wrong with that sale, but then that money and others was used to purchase the Fairbanks Ranch property, and that's why the lis pendens filed by the Department of Justice. And so it's also disclosed as a by a recorded notice, of course. They've recorded the notice that there is a lawsuit pending because they want everybody to know that if you're going to go buy in this property, you need to understand that there are going to be some possibilities that what would happen. So the question to me was, can he sell the property? And the answer is, yeah, he can. But here's the downside to that. If the Department of Justice is successful in enforcing their lawsuit and they take the property, you lose everything you paid for the property. Okay, because you knew about it. You knew that there was a lawsuit pending, right? Lis pendens is Latin for lawsuit pending, and so you knew about it. And so that's why you can't be sympathetic to that. Ultimately, the Department of Justice was successful in taking the house. It never did sell. I mean, it would certainly, I wouldn't want to represent the buyer, but I don't know what to tell you. So anyway, in this case, a pending court action, ABC Enterprises, once again, 2014. So literally after one of the mortgages was put on, but not the other. And again, usually denotes a dispute regarding the land as to ownership, liens, or other matters. Okay, so again, remember we have liens and encumbrances, we have easements, we have things like that are all included in the preliminary title report, but it's not the end of it. It just says that as of 7:30 this morning, this is what we're prepared to issue a policy with. So I just did a transaction where our buyer, our agent, was very good with all of this, constantly calling the title company, constantly looking for an update on the title on the property. And so ultimately, unfortunately, that's not going to go well for the seller or the brokerage. So anyway, so this is who it is. And then if I want to see what it looks like, I go in there and I grab 9784. Everybody good with that? So that's my end of my Schedule Bs. Remember what I said before, all of my lawsuits are in the Schedule Bs. Okay, so we want to make sure. So what was commonplace back in the day of Shirley Hayes was documents that would say, like we see here, recorded, here's the instrument. So, you're just giving me a summary of this. So what does the document actually say? So it would actually, the title would have said, reference such and such for further particulars, which means that there's more information somewhere, but we're going to pass off on it because we told you about it and you had an opportunity to ask. Now, in the current title reports, I'm seeing they're getting even better. In the current title reports, these would be clickable links. So you could click on it, it would pull up the actual document so that you could read it. And so, that is their way. They send this electronically. In the old days, you got this packet in the mail. They don't do that anymore. Now they send this electronically to you, and then they have hyperlinks in there that reference the documents that your buyer needs to be reading. Needs to make sure that the property is as they intend to their use of the property. I had a transaction also in Del Mar where the buyer had actually read the CC&Rs. They were operating a home-based business. And the CC&Rs say you may not operate a home-based business. And so they looked at it and they go, well, wait a minute, we're going to have a lot of UPS trucks coming by, dropping stuff off. And so stuff's going to be going in and going out of our place. Clearly, the homeowner association would be aware of the fact that we were running a home-based business, and they elected not to purchase the property because of that. So kind of disappointing, but boy, would you rather they find out about that prior to closing or after closing? So after closing, you get to play in that lawsuit, but they fortunately were good enough about reading the CC&Rs of the property before making a decision whether to move forward or not. Everybody good with that? Okay, so those are my Schedule Bs. Okay, so Then I get into my requirements. Number one, we're going to require the following documents. So as we said earlier, prior to issuance of any title assurance, we're going to want to know who this 1234 State Street is, copy of the operating agreement. If a domestic limited liability, I've explained to you now what a domestic means, copy of its articles of organization, all amendments thereto. If it's member managed, all this stuff. If it was formed in a foreign jurisdiction, so a foreign corporation or whatever, evidence satisfactory to the company that it was validly formed, is in good standing and authorized to do business. So, for example, every year we assert our corporate status of the state of California. So it's the law. We have to do that. What else? If less than all members or managers as appropriate will be executing closing documents, furnish us with the evidence of the authority of those signings. So remember that with a corporation, you have a statutory agent, and that statutory agent has a document that says, I am authorized to sign on behalf of the corporation, including all of the members of the corporation, all that kind of stuff. I'm the one who does the signing. If you have a trust, which is almost half of the transactions that you're going to do in San Diego County, now we have a trust cert, and that's usually going to be a 1 or 2 page document that says this person or these persons are authorized to sign on behalf of the trust. I did a transaction on Avocado up in Leucadia where 16 members of the trust, all related to each other, showed up at the listing appointment. It was a field day for me. There was one spokesperson for the entire thing, and we were hoping he was going to survive the transaction. He did not look well. Poor young man had a lot of different issues. And so all 16 of these people were nurses, by the way, including him. So it's just kind of weird, but anyway, he was the signatory. He was the trust cert. He was the person authorized to sign on behalf of all 16 people. And so that was a document that we got that said that, this is my authority. You know that in your contract where it says evidence of representative capacity. So when you do your RCSDs, anytime you have something signed by a non-natural person, so you have natural people, you and I, you prick, they bleed. A non-natural person is everybody else. Okay. Anytime you sign on behalf of another, whether it's power of attorney, whether it's a corporation, any of these other things, you need evidence of the fact that you are authorized to sign on that behalf. And title's going to be looking for that. So for sure, even our contract says that the buyer and the seller will provide to each other the appropriate documents within 3 days after formation of the contract. Title is clearly going to need that because they're ultimately going to be the ones who decide whether or not this transfer is going to stick. Okay. All right. So again, when you're filling out your purchase agreement, your RCSD, for example, would have the name of the seller as the name of the seller, the company, the corporation, the trust, the probate case number, those kinds of things. They would have that on the document, and then they would have the person authorized to sign on behalf of that as the signator. They're not the owner. They're the person authorized to sign on behalf of the owner. So whenever I look at my tax record or my grant deed and I see somebody other than a natural person, that's the name that goes in under seller. Okay. And I need to be very careful about that. I mean, what I said earlier, I want to make sure that I'm creating a contract between the buyer and the seller. So I need to be very clear that I'm not putting matter of record or on file or something else hokey like that, because again, ambiguities in the contract are construed against the author. And yes, that is a legal term. Okay, everybody good with that? So I want to make sure I've got the actual seller on the contract in order to commit the seller to the contract. Okay, all right. They reserve the right to add additional items, of course. Any rights of parties in possession. So again, not disclosed by the public records. So the company is going to require for review a full and complete copy of any unrecorded agreements, contracts, licenses, or a license. Remember what I said? A license is is a lot like an easement. It tends not to be recorded. It tends to be revocable by the party giving the license. So, I give you license to cross across my property to go to the fishing pond over there. I didn't give you a fishing license. I gave you a license to cross my property, but I can revoke it at any time. And if at any point either one of us sells our properties, then the license goes away automatically. So either way, license not nearly as, not recorded. It's not nearly as protective as an easement would be. Okay. All right. So what else? Because tenants have a right of possession and most leases are not recorded, copies are required of any unrecorded leases that may affect the property and usually, long-term effects on the property. Okay. All right. And then there's my statement of information, otherwise called a statement of identity. The company requires a statement of information to be completed by the following parties. They just want it from everybody. All the parties now. You're not a party. Remember, you're an agent. The parties are the buyer and the seller. Okay. All right. So that being said, I think that's gonna, let's see here, informational purposes. We got all kinds of stuff, medical marijuana sale. I just sold a commercial building in Solomar, and it included, the buyer was going to turn it into a medical marijuana dispensary. Okay, it works, I guess. And then further explanations of the things that we've been talking about here today. Let me scroll down here. Wire fraud alert. Everybody's doing wire fraud alerts. Usually, if you can get to the FBI within 24 hours, they have a possibility of reversing the wire. But the bad guys are good enough to know that they need to move that money out of that account really quickly in order to keep that from happening. So here's FBI.gov. You can also go to IC3.gov. Okay, privacy notice. We all have to do that. And then I have one more little tidbit in here. Yeah, we do all kinds of crazy things. And here's my California Online Privacy Protection Act. Your legislative body at work. California discount notice of available discounts, because this title company misbehaved at some point, and so they give rebates to people. So, but you got to figure out whether or not it applies. It's true for all of them, right? None of them are really exempt from any of this. I remember there used to be a saying that everybody takes their turn in California. So available discount, credit for prelims, and disaster loans, churches or charitable nonprofit organizations. Remember, the title company must publish their rate. They can't make rates up. It used to be that, the title rep would give you a discount for repeated business, but they can't do that. And so they have to follow their pre-printed policy, whatever the policy says, that they have to charge that. So here's my standard coverage policy. Again, this is my CLTA, my standard coverage policy. And so it's going to go through those things. Here's exceptions from coverage. Here's my exhibit B. This is my CLTA. But the Alta homeowners policy of title insurance, and again, the exclusions. And then finally, when I get down into my exhibit Bs, there's my Alta loan policy, exclusions from coverage. It's all about exclusions, folks. Okay. And then there's my Alta owner's policy, if any, et cetera, et cetera. Okay, so I think that, okay, here we go. Plat map. This is what I wanted to get you to. Your state and county tax map layout could vary, but I'm looking for, in this property here, what are my numbers again? So parcel numbers. So this is a really good breakdown of what these different things cover. So obviously A is the parcel number. So here's the numbers, number 12. So that's, we're buying number 12. I thought the original document said 78. So we're buying number 12. Paragraph B is going to be, where did B go? B is over here on the left, and that's going to be my book and page circle. Paragraph C is going to be my lot number. That's it right here, number 19, et cetera, et cetera. North arrow, if any. It won't always be pointing up, by the way. That's true story. But I kind of like that north arrow because I depend on that for flying purposes, et cetera, et cetera. So anyway, pretty good little breakdown of the property, and obviously the information that we need to know to do to review the title insurance policy with the purchaser of the property. Normally, our review is more for the purchaser than the seller. The seller, there may be things in there that the seller wants to know, doesn't want to know, whatever. So okay, so that being said, let's go back to our PowerPoint really quick here. And so that's what we did. We just took a look at a preliminary title report. I want to remind you that when you define your duty, you limit your liability. And I say that because when you do the buyer representation agreement with the buyer, it has explicit instructions in it of what you're going to do. So one of those is to help you review the preliminary title report. Okay. So the good news is when you tell them what you're going to do, it's difficult for them to come back and litigate with you over stuff that you didn't tell them. So because it's laid out. And then again, you want to read the document because you don't want to do things that the document says you're not going to do. Okay. You could be increasing your own liability. So again, I like that for purposes of the buyer representation, which I think I'm doing next Tuesday. I'm going to do the buyer representation agreement next Tuesday. I believe, I'm sorry, I don't know for a fact, but it'll be, today's the end of this day. On Thursday, I'll publish what I'm doing on Thursday and then on the following Tuesday. Okay. So again, very important point, define your duty, limit your liability. And I want to thank you for joining us. Now I got a couple of other things for you. So I've got a new YouTube website. I've loaded a bunch of stuff. All of my videos I'm loading up on the YouTube website. So if you have a QR code reader, here it is. Go ahead and read the QR code, and that'll take you straight to the website. Personally, I think good stuff. And how to read the preliminary title report is probably one of the most viewed of my webinars. But you can also get there by going to bit.ly/real-estate-ed. Please remember when you go there, like and subscribe. So again, liking because it makes me feel good. Subscribing means that when I post these videos and you go logging into YouTube, it doesn't blast you emails and stuff. But when you log into YouTube next, it'll say, oh, by the way, Kevin posted, these new videos. Okay. Because I update these things all the time. But it gets even better. So when you subscribe, again, not only does it make me feel good, and I don't get paid for any of this, right? You viewing it or liking it or whatever. But if there are other topics that you want to see us discuss, let us know. I come to brokerage offices. I do things like that. It's up to you. Just let me know how I can help. You can send an email to education@sdar.com. You can copy me. You can send it to me. You can copy them. Whatever. We're all in this together. We all want you. I don't work for SDAR, but SDAR has decided that they want to help support the professionalism of our industry. And that includes what we're doing right here today. Okay. So weekly emails. So I do send email updates every Friday. Again, I'm trying to think, did we send one out? I think, God, I hope we did. I'll have to take a look. But anyway, yeah, I don't put people on it unless you ask to be put on it. So you have to send a request to be subscribed. It's also in my signature line. It'll say, click here to join the newsletter. I've got a 63% open rate. So, apparently there's some value being provided here. I've also got the new forms, by the way, the ones that are coming out in December. CAR put them up on their webpage, but then they took them back down. Well, but not before I grabbed them. Okay, so I've got them. I want you to know what they look like. They want input from us as to our thoughts on it. So those are going to be important things. Okay, so stay tuned for our podcast. So we're doing some shifts in what we're doing. The 2-hour webinars notwithstanding, we're going to, for example, I'm going to do the buyer representation agreement. Let me talk about that in a minute. On Friday of last week, the Department of Real Estate asked me to tape a podcast with them. Interview went on for an hour and a half. An interview over the legal documentation necessary in a real estate transaction in California. So there's the actual link. So you go to dre.ca.gov/consumers/first home California.html. So I'm blowing this all over the internet. I'm very excited about it. So on November the 29th, they're going to publish the one that I did on Friday. You got to clean up all the bad language and do stuff like that. So anyway, I'm honored to be asked by the Department of Real Estate to do that. I've had a couple of high points in my career with the department. Anyway, important stuff. The majority of complaints, interestingly enough, filed with CalDRE are from first-time homebuyers. I learned that the other day. They told me, they said, "Oh yeah, the majority of our complaints are all first-time homebuyers." I said, "That's really sad for us, because that means that maybe we don't know what we're doing, and maybe we shine it on with the first-time home buyer, hoping that they won't care. It's like, don't worry about it. Just sign here, date here. Everybody does. That's definitely not a good defense, clearly. So I'm just saddened by that fact. But first-time home buyers, I think, are incredibly important. I have made a career off of entry-level housing. I would just as soon do a $300,000 transaction than an $8 million transaction. And the $300,000 transaction is going to be more appreciative. They're going to send me more referrals. There's a lot of reasons why I like to work with entry-level housing. And again, if entry-level housing fails, we fail. I mean, we saw this happen in 2003. In 2003, the entry level, the bottom of the market just stopped. It just came to a complete halt. And so what happened? Well, in 2005, see, here we are lolling around thinking that, everything's fine. But then in 2005, all of a sudden, the high end stopped. And so the high end was kind of propping everything up and making us believe that everything was okay. But that's when we discovered in August of 2005, we discovered that the entry level had stopped back in 2003. And so now we're in trouble, right? And that's when, all the collapses and all the foreclosures. And then that's where short sales came from. Because the banks were essentially, it's like drinking water from a fire hose. And so they were given tax incentives and things to not foreclose, but instead to do short sales. And so that's been kind of the law of the land ever since. But that's what happened. So we had our SISAs, our stated income, stated asset loans, our liar loans. They're not allowed anymore to call them no doc loans, things like that. So be very aware of that. I think it's sad. I like working with first-time home buyers. Again, as I said, they tend to be most appreciative for what I do. So stay tuned for my podcast, because I'm going to start on that theory. I'm going to start doing podcasts based on we're going to start probably with a buyer representation and broker compensation agreement. Okay, so we're going to start with that. Why? Well, the Burnett case came down a couple of weeks ago, and interestingly enough, it affected, it didn't affect me and our business at all. Because why? Because in our business, we use buyer representation agreements. All of our agents use buyer representation agreements with the buyer, like it or not. Right. In Virginia, where I teach in Virginia as well, I'm a broker there. I have a broker's license there as well. They made it a law on July 1st of last year, which means that you may not be paid, you may not represent anyone unless you've got the buyer representation agreement. So Virginia said, "Hey, we don't care about the Burnett holding." Them and 13 other states said, "We've been requiring buyer representation agreements for a long time." And interestingly enough, the attorney for CAR made a comment in a meeting I was in with her last week, that if we have to make it legislative in California, we can do it pretty quickly, and I think they're going to need to do that. So, but get good at it. I'm probably going to do these in paragraphs, so you'll be able to just pull up paragraph number 4, which is all about the commissions, that kind of thing, the ones that you want more information on. So be aware of that. Okay, so it's kind of a big deal, and that should not be the end of our presentation. What happened to it? Screen sharing has stopped. That doesn't make any sense. What did I do? Let me see if I can figure it out. I think I might have done something wrong with the computer. Oh yeah, I did something wrong. I actually that all should have been before I gave you my email address. So there's my email address. And so again, I want to help you. anything I can do for you, please let me know. I do thank you for being here today. If there aren't any other questions, I do want to thank you for being here and appreciate your time. And as we say from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Have a great day. Hopefully see you again on Thursday. Take care for now. Bye-bye.